Yes, hello to everyone. I welcome you all to this new daily news digest session. Today is 10th of January, and I have a few articles from both the Indian Express and the Hindu. My first article is from the Hindu, which basically is dealing with the section 152 of Bharatiya Nyaya Sanhita and why it should not become a proxy for sedition. Let's try and understand this. There are a lot of Supreme Court related judgments which have been mentioned here. I think the students should make a note of these judgments because they can uh, act as a fodder point for your mains answers. The Rajasthan High Court in Tejinder Pal Singh versus State of Rajasthan cautioned against using Section 152 of the Bharatiya Nyaya Sanhita as a tool to stifle legitimate dissent. In 2022, before the Bharatiya Nyaya Sanhita was enacted, the Supreme Court had suspended pending criminal trials and court proceedings under Section 124, Clause A, that is sedition of the Indian Penal Code, until the government reconsidered the law. This was followed by a verbal proclamation by the Union Home Minister that sedition would be repealed as an offence. That was the message that was given. Section 152 of the Bharatiya Nyaya Sanhita criminalizes any act exciting secession, armed rebellion, and subversive activities. It also criminalizes acts encouraging feeling of separatism or endangering the sovereignty, unity, and integrity of India. While the Bharatiya Nyaya Sanhita does not formally use the term sedition, the Rajasthan High Court's decision hints that the spectre of sedition still looms large in the Bharatiya Nyaya Sanhita. What is the problem with Section 152? Let's try and figure that out. First, Section 152 of the BNS criminalizes acts endangering the sovereignty, unity, and integrity of India. However, what constitutes such endangerment under Section 152 has not been very much defined in the statute. So that renders the provision quite vague and amenable to expansive interpretation. Apart from that, a speech criticizing a prominent historical or political figure or sympathizing with a controversial public figure may be construed as endangering the unity and integrity of India for initiating legal action against a person. That makes it slightly overwhelming, which is a very stringent penal provision. The article also is saying that, secondly, the term knowingly in Section 152 substantially lowers the threshold for commission of the offense, especially in the context of social media. Even if a person does not have the malicious intent to incite activities or feelings prohibited under Section 152, they can still be considered liable for the offense if they share a post knowing it will reach a large audience and may provoke such activities or feelings. This would be sufficient to arrest a person and prosecute them for commission of the offense under Section 152, which is a cognizable and non-bailable offense. The lack of a statutory requirement to prima facie establish a causal linkage between the speech and its actual consequence before depriving the accused of personal liberty renders Section 152 amenable to abuse, much like its predecessor, and has the potential to instill a chilling effect on free speech. It can have a potential of stopping free speech. The potential for abuse of the sedition-like provisions is clearly borne out by the data of the National Crime Records Bureau regarding Section 124A of the Indian Penal Code. What is the way forward in this regard? In the past, judiciary has consistently adopted a consequentialist interpretation to strike a careful balance between national interest and the freedom of expression. The choice of words in this article is very, very good. And please ensure that you pick up this content and note it down in your notes. It will add value to the answers you are writing. Supreme Court has given weight to the actual consequence or impact of free speech in determining the offense rather than considering the speech on its own. They've mentioned a case in Balwant Singh and ANR versus State of Punjab. The court drew a line of demarcation between casual sloganeering and its repercussions or consequences. They've also mentioned the Javed Ahmed Hazm versus State of Maharashtra and others case, 2024, in which the court said the effect of the words must be judged from the standards of reasonable, strong-minded, firm and courageous men, and not of those of weak and vacillating minds. In the Kedarnath Singh versus State of Bihar 1962, the court has differentiated disloyalty towards the government from strongly worded criticism of the government and its policy. These are two different things. All these case laws and their eventual outcomes are very, very important from your exam's perspective. Please read them for your better understanding. It is important to provide liberal space to thoughts, beliefs, and expression, and to subject them all to unimpeded criticism. Especially in the age of social media, we need to fall back on the concept of marketplace of ideas, as envisioned by Justice Holmes in Abrams versus United States, because the best test of truth will always be the potential of an idea to get itself accepted in a democratic and diverse society. Sorry. Yes, now I am sharing a question that can be potentially made from this article. Consider the following statements with respect to Section 152 of the Bharatiya Nyaya Sanhita, BNS. Section 152 explicitly uses the term sedition to describe criminal acts. It does not. explicitly use the term sedition. This is wrong, first statement. It criminalizes acts that endanger the sovereignty, unity, and integrity of the country. This is correct. The provision lacks a clear definition of what constitutes endangerment, leaving it open to interpretation. This is also correct, as seen in the article. Lastly, the judiciary has advocated for a causal link between speech and its consequences to determine criminality in such cases. This is also absolutely correct. 2, 3, and 4 is going to be the correct answer to this question. Moving to the next article. This article basically is from the Indian Express. Same-sex, Supreme Court closes door on same-sex marriage again, rejects review plea, says no interference is warranted. Let's try and read as to what this is. The Supreme Court recently dismissed petition seeking review of its October 17, 2023 ruling that had rejected the prayer to grant legal recognition to same-sex marriages. At the moment, same-sex marriages are not recognized legally. A 5-judge bench of Justice B.R. Gavai, Suryakant B.V. Nagaratna, P.S. Narasimha, and Dipankar Datta, which considered the petitions in chamber, found no error apparent on the face of the record of the majority view authored by Justice retired S. Ravindra Bhatt in the 2023 ruling. Citing institutional limitations, the 5-judge bench at that point in 2023, in 4 separate judgments, declined to strike down or tweak provisions of the Special Marriage Act 1954, saying there was no unqualified right to marriage and a same-sex couple could not claim it as a fundamental right under the Constitution. Rejecting the prayer to grant legal recognition to same-sex marriage, the bench had left it to the Parliament to change the law to validate such a union. Supreme Court refused to recognize same-sex marriages, and basically the ball was rolled in the under the Parliament's lap as to a law to validate such a union. This has further once again been recently upheld. While agreeing what was there in the 2023 ruling, the then Chief Justice of India, Justice Chandrachud, and Justice since retired Kaul, who were part of the 5-judge bench, spoke in favor of a civil union, but it ended up being the minority view. CJI Chandrachud said that this right to civil union or right to enter into an abiding cohabitational relationship could be traced to Part 3 of the Constitution, that is, fundamental rights, and thus placed a positive obligation on the state to accord recognition to it. While agreeing that there is no fundamental right to marry, CJI Chandrachud also said there is a right of freedom to enter into a union as laid down in various judgments of the court, which are Navtej Johar judgment, the KS Puttaswamy judgment, the Nalsa judgment, Shakti Vahini, and Shafeen Jahan judgment. And that, having regard to our constitutional values, which entail respect to the choice of a person, whether or when to enter into marriage, and the right to choose a marital partner. You must have read these concepts in your static polity notes as well. This is one article which is helping you revise those concepts. The review petition filed against the judgment said the majority ruling suffered from errors apparent on the face of the record and was self-contradictory and manifestly unjust. But however, this review petition was recently done away with by the Supreme Court. And the right to petitioner contended that the majority judgment overlooks that marriage at its core is an enforceable social contract. The right is to so contract is available to anyone capable of consenting. Adults of any faith or no faith may engage in it. No one group of people may define for another what marriage means. No contract nor forcible state action like imprisonment may curtail an adult's fundamental right to marry. The petitioners said the judgment warrants review because it summarily disregards what was said by the court in earlier decisions to make the chilling declaration that the Constitution of India guarantees no fundamental right to marry or form a civil union. The judgment, they argued, effectively compels young poor Indians to remain in the closet and lead dishonest lives if they wish the joys of a real family. It is fallacious that under these facts, and in the absence of a fundamental right to marry or form a union, the rights to equal protection, dignity, and fraternity are insufficient to justify judicial intervention. This was basically said in the petition, but since the Supreme Court, Honorable Supreme Court has basically dismissed this particular petition, the current status is that same-sex marriages are not recognized as legal unions. But the ball has been set rolling in the lap of the Parliament. Next, there is one question that I've prepared from this article, which has a potential of being asked. Let's try and discuss that. Consider the following statements regarding the Supreme Court's ruling on same-sex marriage in India. The Supreme Court in October 2023 ruled that there is no fundamental right to same-sex marriage under the Constitution of India. This is absolutely correct. The court upheld that any changes to the Special Marriage Act 1954 to validate same-sex marriage should be made by the Parliament. This is also correct. Chief Justice of India, Dhananjay Chandrachud, in a minority view, supported the right to a civil union for same-sex couples, citing Part 3, that is fundamental rights of the Constitution. This is also correct. The review petition against the October 2023 judgment was upheld by the Supreme Court in January 2025. It has been dismissed or rejected by the Supreme Court. So 1, 2, and 3 is the correct answer. Just one more article from the Indian Express that needs to be discussed today. The article basically is on the migration of data transmission system and which led to a gold counting error as said by the government. Let's try and figure out as to what this is. The Commerce and Industry Ministry on Thursday said that the overestimation of gold import figures between April to November was a result of an error that took place due to migration of data transmission mechanism and subsequent double counting of imports coming into special economic zones, considered foreign territory and clearance of two domestic zones. The explanation comes a day after the ministry revised the gold import figures for November, lower by $5 billion to $9.9 billion from $14.8 billion, narrowing the overall goods trade deficit for the month to $33 billion from $38 billion. It was observed that due to migration of data transmission mechanisms from SEZ to Indian Customs Electronic Gateway, IceGate is a very important portal. This becomes important. Figures of precious metals needed revision, as it was noticed, as the system was calculating both imports into SEZ and subsequent clearance into domestic tariff area as separate transactions after the migration. They need to be calculated together. The ministry said that the DGCI and S receives data on trade data from over 500 locations and about 2.5 lakh transactions every day from different seaports, land ports, airport, and inland container depots. And trade data from more than 100 SEZs was earlier captured by SEZ online system, and export-import data for all other ports was captured by the IceGate system. This article also has a very good table which helps the understanding. Before revision, April to November 2024, the gold import data was $49.08 billion. After the revised data, it became $37.39 billion. Apart from this, November 2024, before revision, it was 14.86. After revised revision, it became $9.84 billion. And country-wise gold import, before revision, it was UAE, which gave the maximum amount of gold to India. It was 11.63. It was reduced to 7.98. Switzerland from 9.45 to 8.45. South Africa from 3.45 to 2.38 billion. Both systems, IceGate and SEZ Online, were transmitting the data, trade data separately to DGCIAS for publishing foreign trade statistics. However, based on a decision to shift EXIM declarations from SEZ portal to IceGate, the EXIM data pertaining to SEZs as well as other ports is being captured and transmitted by IceGate to DGCIAS. The principal commodity, this is basically the core part of this answer. The students, basically what they have to do is, from this particular article, they have to make sure that they discuss the various initiatives, the various agencies that have been mentioned here. And the revised data can be assessed through the data dissemination portal of DGCIS. A committee has been formed with stakeholders from DGCIS, DG Systems, and SEZ for creation of a robust mechanism for publishing consistent data so that such errors do not happen in the future. Now let's discuss one question which has been prepared from this article. The Ministry of Commerce and Industry recently revised the gold import figures for November 2024. What was the primary reason for this revision? First, a significant reduction in global gold prices leading to lower imports. No, this was not the case. Double counting of gold imports due to migration error and data transmission mechanisms. This is exactly the right answer. Government policy change reducing gold import quotas in special economic zones. This was not the case. Errors in trade data reported by the IceGate, Indian Customs Electronic Gateway. So the most appropriate answer here is double counting of gold imports due to a migration error in data transmission mechanism. So this marks us to the end of today's session. Thank you so much. We'll meet again.